work made for hire doctrine is one of the truly important contributions of the copyright law. Having a creative work designated as a work made for hire can make a huge difference in the value of the copyright and can create a financial disaster if you get this wrong. The work made for hire doctrine is so often misunderstood and misapplied. We're going to clear all this up in today's video. Hi, my name is Carr Ferrell. I'm a Silicon Valley intellectual property attorney. Welcome back to my channel. A copyright is an umbrella of exclusive rights given to authors of creative works in tangible medium. And this could be pen put to paper or brush to canvas, something stored in a hard drive on your computer or in a shiny warehouse in a data cloud center in Tennessee. These exclusive rights given to authors include the right to copy, to publish, to perform, to display, and to make derivative works of the original work. I've made lots of videos on copyrights, including photography, music, tattoos, and many others, so I won't go into the details of copyright law in this video, but I will provide some links to some other copyright videos in the description section below. The owner of the copyright is usually the creator, the person who created the work. But there are two exceptions where the creator is not the owner of the copyright, but rather the person who paid for the work owns the copyright. Both of these exceptions fall under the work made for hire doctrine. Now, the work made for hire doctrine is defined in Section 101 of the Copyright Code. There's no other statutory basis in intellectual property for using the term work made for hire, unless this term is otherwise defined somewhere in a contract. When we see the words work made for hire, we think about copyrights and copyright law. Honestly, it hurts my head when I read contracts that say all patents, trademarks, trade secrets, and know-how are works made for hire under this agreement. The work made for hire doctrine is a copyright designation. As I said, under copyright law, there are two exceptions to the creator of the work actually owning copyrights in the work. The first exception under the work for hire doctrine is when an employee performs work for an employer in the normal course of their job. They create some work of authorship as part of that employment. The creative work is owned by the employer and not the employee. Now, there are two important parts to this first exception. First, there has to be an employer-employee relationship. And secondly, the creation has to be in the normal course of their job. They were being paid in the normal course of their work for the copyrighted work of authorship. Now, the copyright laws don't define the term employee, but there's a leading Supreme Court case on the definition of employee as it relates to copyrights. And this is Community for Creative Nonviolence versus Reed. Now, in the creative community case, the Supreme Court takes the common law view of employee. They look at common sense factors like where was the work performed? What was the skill of the creator? Who had the right to set hours and who provided the tools? Did the creator have the right to hire an assistant? And if so, who paid for the assistant? So it's a definition of employee based on a common sense analysis of a variety of factors surrounding the creative work. Once we make a determination of whether the creator was actually an employee, then we have to decide, was this work done as part of the normal job of the employee? I had a client some years ago who was a mechanic at an auto dealership, and he would repair cars during the day, but his hobby was programming, and at night he would go home and he would work on a computer program, and he developed a computer program that would help with the repair of cars. And this computer program would look at car data and pull data off the internet, and it would make predictions about when a car would need repair, the type of repair that would be needed based on the symptoms, the tools that might be needed, what parts would need to be ordered, how long the repair would take, and normally how much the repair would cost the dealership. And under the work for hire doctrine, he might have been an employee of the dealership, but he was not being employed by the dealership to write software or to create a software program for them. He was just an auto mechanic hired to work on cars. And the fact that he worked on this computer program on his own time at night, using his own computer, his skills not related to the skills he was hired for, the copyright in this software was clearly his and not owned by the auto dealership under some theory of work made for hire. Now there's a second category of employment that creates copyright ownership in the employer under the work made for hire doctrine. And it's this second category that creates so many problems and so much confusion among copyright owners. When a work was specifically commissioned for use as a contribution to a collective work, as part of a motion picture or audiovisual work, as a translation, as a supplementary work, as a compilation, as an instruction text, as a test or answers for a test, or as an atlas. And if the parties expressly agree in a written and signed agreement that the work shall be considered a work for hire, then in fact the work is a work for hire, and the author of the work is the employer and not the creator. Now, a couple of things to understand about this second category of work made for hire. First of all, this is not an employee. This is an independent contractor. Secondly, only works under these 9 specific categories qualify if Google hires you to draw a street map of my neighborhood so that I can find my way home using Google Maps. Then that could qualify as a work made for hire under the Atlas category, so long as there was a written agreement in which both you and Google agreed that this would be a work made for hire. However, if they commission you to build a statue on the front lawn of Google's headquarters, this would not be a work for hire, since the creation of statues is not one of the 9 categories set forth in the work for hire doctrine. Whether there's a written work made for hire agreement or not, you alone would be the copyright owner in that statue. Now, it is possible for you to assign your copyrights in that statue to Google. However, they would not be, in the first instance, the author of that statue. So this really begs the question, why is the work made for hire designation important? Why do we care whether a creative work is a work made for hire or just a work that's assigned by a third party? Well, there are 2 important reasons why this work made for hire doctrine is important. The first reason relates to the term of the copyright. Copyrights in individuals last for 70 years from the death of the author. Copyrights owned by corporations last for 120 years from the creation of the work, or for 95 years from the first publication. So under certain circumstances, a corporate ownership in the copyright might be more beneficial with respect to copyright term. And the second reason, and probably the most litigated reason, as to why this work made for hire designation is important, has to do with something called reversionary rights. Under copyright law, when a creator assigns their copyright to a third party, after a period of 35 to 40 years, the copyright owner or their families can go in and terminate that copyright assignment. This right of reversion does not apply to works made for hire, but only to works that were assigned by the creator to a third party. So because of this designation of a work made for hire can be very important. And we've seen this come up in the music industry, where a lot of music creators from the 1970s and 1980s are now regaining control of their music libraries. These reversions would not be possible if the authors were designated as employees. Now, this work made for hire designation is not always so clear-cut. Sometimes there's a blurring between employee and independent contractor, or there may be some misunderstanding or uncertainty as whether the work that's being created actually falls under one of the 9 specific categories set forth in the Copyright Act for works made for hire. So because of this, when drafting a contract containing works made for hire language, it's really important to have a backup clause, a follow-on clause, which says in the event that it's determined that the creative work contemplated in this agreement is not a work made for hire, then the author hereby assigns all copyrights and other rights in the work to the person named in this agreement. There's so much more to say about copyrights and intellectual property protection. If you liked this video and found it useful, I think you'll find this next video helpful as well. And by the way, if you found this video useful, I'd really appreciate your liking and subscribing. Your engagement with this video helps YouTube recommend my channel to other people looking for video content just like this. Thank you so much for being here, for liking and subscribing. I'll see you on the next video.